joining us physically?
No, he's gonna virtually attend this one.
Testing 1, 2, 3.
Mark.
Hi.
How are you?
Hey,
Oh,
Mark.
no worries. Still not sure where Tony is, but I did email, Andy's in New York, and he said he would be available online, so I emailed him and asked him to jump on if he is able to do that. Oh, but we do have a quorum. Yeah.
How are you?
Good, how you doing?
How you doing?
All right,
Good.
we're good. All right, so welcome to the May meeting of the Zoning Board of Appeals. The first thing on our agenda is to approve, we have 2 months' worth of meetings to approve. I'm going to make a motion to approve. Second. All in
Second
favor?
that.
Aye.
Aye.
All right, those are approved. And then this next thing, we're going to skip to petition 2305, which is Lodge Road, because they did not sign their continuance yet, so I'm just gonna make a motion to continue petition 2305 to our June meeting.
Yes, June meeting.
What, did they
June
sign
13th.
a continuance?
They did not sign a continuance.
So, have you been in touch to see?
I have been in touch, yes.
And they said they will sign a continuance?
Yes.
Okay,
Yeah.
so subject to their,
Subject to
So
their
subject to their signature, sure. Yes,
okay.
thank you.
All right, great. I'll second that motion.
Okay, all in favor?
Aye.
Aye. All right. So that brings us to petition 2304 for the request to, for Humphrey Street. And we have Mr. Schutzer here.
Could I fifth member on now?
What's that?
Is the fifth member virtually with us?
Not yet.
Could we wait to have the fifth member, please?
Yes. We can wait. So we can do that, your clients know that, if you have, if we have 5 members, you need 4 yes votes. If you have 4 members, you also need 4 yes votes. So that's why, it's good to have a 5th member.
No, that's okay.
So what about,
We do have one other that's a
the
continuance.
2225, is that one?
That's
Or-
already, that's all set, right? Because,
We have a signed continuance.
Oh, I thought there was a third, I had the agenda from the other day, and it was, which I thought,
2225 has been continued. Do we still do that? Do we still?
Do we still motion to continue, Mark, even if they've signed?
They've already signed ahead of time.
and what about, 2305 is number 2, number 3,
No, 2225 is the
Right,
Clear
that-
Road. They've already continued,
All right,
signed
so
their
they-
continuance.
they signed their continuance,
Yep.
and this one here with,
That's one we just did.
that's one we just did, okay, all right. I'm caught up now.
Yeah.
This is Andy. When does the new woman get sworn in?
I don't know. Yeah, we have one member. Or no,
What-
we have someone who's,
Interested, or?
yeah,
Okay,
so I
that'd
don't
be
know
great.
if they've gone to. She came to the last meeting and she was going to go to,
The select board?
yeah, so I don't know.
Yeah,
They were,
I haven't heard anything.
Yeah.
So I'm sorry, I've been like out of pocket if you need any questions or anything. You're doing great. I would have, but I've been so busy, but it just like ended yesterday, like
Oh, good.
since January, I've been crazy.
I just wasn't,
Good now.
So like summer.
my impression.
We can have some.
I was trying to get all this stuff done
Fun.
for summer.
Andy is unable to sign on. Do you have Tony's number, Mark? I don't have Tony's number.
Let me see.
Can I ask a question? My wife's on, waiting to be invited in.
Oh, let me see.
Exclude your wife.
Interesting. Usually her name would pop up somewhere over here, but I don't
Have
see
Tony's
it.
number or not? I thought I did. Oh, here we are.
What about Brad? Is he
Brad is unable to attend. He emailed me about a week ago.
even virtually?
I think so. He said he had a last minute conflict. She's not, no.
I went right to voicemail,
Okay.
text them too.
Did you just close last week?
We can have it.
So I went right to voicemail, I just texted him as well.
Okay.
You can see if we give Tony a few minutes to reply, but.
Now, Andy says Andy's available, you can speak with him, but he can't get on by phone?
He's at a restaurant.
Oh,
I could hear music in the background.
can he excuse himself and kind of go into the men's room and talk from there?
Didn't seem like he was in that kind of setting.
Is there a minimum time frame for, or a maximum time frame for delayed meeting?
I don't believe so, no. Do you guys know anything about that?
No.
We do have a quorum, so, we could proceed. It's been the request of the petitioner that we try and allocate a fifth member, but,
Which, we can give him a few more minutes and see.
yeah.
I mean, otherwise, the option is to continue with 4, and if you have,
If I could get a sense of the board before we could do that.
yeah,
then
you
we
get a
could
sense of the
started.
board before we vote, and then if you feel like you have 2 no's, well, then it doesn't matter if there's a 5th member. If you feel like you have 1 no, you might say, hey, let's postpone until next month when we can get a 5th member. And if you have 4 yeses, then obviously you don't need to postpone at all.
Well, we'd have to continue anyway at that point to give the 5th member the opportunity under Mullen to at least to be able to review the video, and they would be in a position to vote if necessary. All right, I think, can I just explain the dynamic of what's going on to my clients? There are 5 members that vote. 3 and 4 of the 5, it's a supermajority. Because there's only 4 voting members now, you need a unanimous vote from everyone. So that's a position that you don't put yourself in. It's a position that unfortunately we're put in because of their failure to have the 5th member here. We can begin, there is a provision which will allow a continuance for a 5th member to watch the video and then be able to come in and vote, but it's not going to occur tonight if in fact there's 1 member who is not in favor. If there are 2 members that are in favor, then obviously I'm not sure the dynamic is going to change, but it's at this point I'm not asking them to take a vote, just to give me a sense of the meeting, and then we can decide what we're going to do from there. They don't want to prejudice us because they don't have the so that's where we are, or we could wait till next month. But under the circumstances, I know that time is of the essence.
Everyone over the last couple of meetings, excellent.
We haven't had tough ones.
You get it all under control. Keeping your,
We'll see
doing a
when we
great
get like a
job.
40B or
Right,
something.
if you
tonight.
don't get a sense of.
I don't think we have too
To a
many spots for it.
I will
No,
ask
that's
them to just, the vote be taken.
No, so
Well,
far.
I'll be able to get a sense of the board before a vote is taken?
Yes, definitely.
All right.
We're happy to do that.
Thank you. All right. We are here and,
Can someone object to this?
So, do you want me to run through what's going
No,
on?
I understand what's going on, so if someone views the video and then you guys talk amongst yourself privately,
We don't.
No, they don't do that. No,
We
this
never
is
told
all
them.
an open session.
No, nothing happens privately. So what would happen in this scenario is, they're gonna present the renovation in the project. They're gonna give it time to speak. You'll be given a time to, say any concerns that you have, and they'll be given a time to try to address them if they can in this meeting. And then they're gonna kind of take a straw poll, meaning where do they think the members of the board are at? And if they don't think they have, the full board support, and they think they can get one more member, they can ask to continue to the next month's meeting, and in the meantime, that member will watch the entire video, and then they will show,
When does he cast his vote?
and then everybody will be here in June,
In June?
and they will hold another meeting, and if there's any more, sometimes you continue because we say, oh, we need more information, so they might have more information to add. It may just be coming back to take the vote, depending on if they don't have any new information.
So the vote of 5 would not take place privately?
No, it would take place at the public meeting in June.
Thank you.
Okay, no problem. All right, go ahead, Mr.
Thank
Schutzer.
you. For the record, my name is Attorney Kenneth SHUTZER with offices in Lynn, Massachusetts. I'm here this evening with Andrew INGEMI, who is the owner of the property at 286 Humphrey Street. Along with Mr. INGEMI is John Sager of Sager Architects from Salem, who has prepared the renderings and the elevations, the photographs that have been incorporated into the package. I would initially indicate that the property at 286 Humphrey Street was formerly Zest Friends Restaurant, and before that, it was Wynn's Restaurant. It's in a B1 zoning district. What is unique about this particular property is that it is part of the Humphrey Street Overlay District, which sort of changes the dynamics of how this property is viewed and the criteria that is required for the relief that we're seeking. The relief we're seeking is called a Humphrey Street Special Permit, distinguishable from a regular special permit, and it's under Section 4700, which has its own set of rules and regulations. One of the components of that was a site plan design review that has taken place before the planning board on 2 separate occasions. One actually occurred last evening virtually, and then there was one before. You should have in your package 2 letters from the planning board endorsing the project. What is left for you to decide is the issue of the buffer between this property and the property owned by Mr. Grimes. Insofar as there are distinct differences between the requirements in any district in this Humphrey Street Overlay District, there's a provision within this particular section, 4764B. It's section, it's section, hold on, I'll tell you a second. It's section,
4761A.
no, I'll tell you which one it is in 1 second. I have it. Bear with me 1 moment. I have this. Oh, here we go. It's under section 4760D. And for section 60D is the exception section, which is distinguishable from the percentage section that we're normally used to dealing with. And it says in essence that the permit granting authority, which is you, may modify all dimensional requirements. So unlike those that are restrictive, under this particular section, it gives you carte blanche authority to modify it as you see fit. Otherwise, if this property was not adjacent to a residential zoning district, there is a 0 side yard requirement. What is interesting is it doesn't require a dimensional setback as much as it requires a buffer, which they identify as a planted area between the respective zoning districts, or in this case, the respective properties. So the relief that we're seeking is to reduce that buffer zone. What I'll tell you further is that there is currently, and I think the photographs so suggest, There's a fence. The fence sits on a wall, and the structure that we're proposing is for a bump out of the restaurant to accommodate a walk-in refrigerator. So there's no windows. It's just a protrusion from the building in the area which has been previously identified for the patio where people have been sitting, at least since COVID started, and they've allowed outdoor seating, which will continue. That portion is now being diminished, so there'll be actually fewer people dining outside to accommodate the walk-in refrigerator, and that's exclusively what it is. It has no windows. It is obviously very well baffled because it's a refrigeration unit, so it's going to be insulated, and it's going to allow from the interior of the restaurant for the cook or anyone else in there to be able to access the fresh foods. What's different about this restaurant, and we'll get into the particulars when Mr. Sager has an opportunity to present his renderings, is that there's going to be a much stronger fresh food provision within the menu itself. Not going to be very much frozen food at all, so they want to be able to maintain a lot of the fresh foods that they're going to be serving. It's primarily a fish restaurant with fresh fish. This is not going to be coming in as frozen fish. It'll be fresh. So they needed to accommodate, and they needed the additional space. The other thing I'll just bring to your attention, and I kind of learned this attending the planning board meetings that they've had, that this is all part of the concept of the master plan of trying to develop Humphrey Street. And in the master plan, they identified as the most successful elements of the commercial area that was being developed is restaurants, small restaurants. And we know that to be true with the advent of G's and Mission, sort of Mission in the Bay as well as a Mission on the Bay now, as well as the other restaurants. They've done well, whereas the other small retailers have suffered, and they have, for whatever reason, haven't been successful. So from listening to the planning board and being made aware of the master plan, this falls well within and is encouraged by the master plan in terms of the development. The prior restaurants did not require as much space for their fresh food as the Dockside restaurant will, and that's the reason we're asking for the relief. And as I said, you have the authority under the provision with the exception. It's unique that because there's no such thing as an exception under the regular standards of regular special permits, but this is distinguishable as a Humphrey Street special permit, and that's the relief that we're seeking, and it's identified as such in the application itself. I'll be glad to go over any of the legal logistics, but at this point, if Mr. Sager could have the floor, he'll be able to show you where it is, its exact location, its height, the area in question, and all the elevations, or any other questions that you might have of either of us. Mr. Sager?
Sure. Do you think we should talk about the?
Sure,
I think we should probably address the 10-foot issue first, just
Yeah,
to,
so what?
because that might change the petition, the application,
Okay.
depending on
So
that discussion.
my reading is that the exception, that D exception applies only to 4761A. It does not seem to apply to B, which is the buffers. So, and because you do abut a residential, that 10 feet buffer zone would apply. That's my reading of the bylaw. I don't know if everybody else on the board agrees, but.
So if I might just respond, so it's your opinion that there is no relief that this board has the authority to
I'm
grant?
sorry, I didn't hear that, Candace.
There is no relief that you believe the board has the authority to grant?
I do.
My read of it is that you have the discretionary language that this board has the authority that they may modify
Right.
4761A, and that 4764B buffers between districts uses mandatory language must, the more intense district use must provide a buffer. So I think they're in conflict, and I was trying to see how you get there. So I think it's a definite issue that I don't know that we have jurisdiction under that discretionary section to modify that buffer with the
Well, it doesn't
residential
use the-
district. I think we could do it anywhere else if you weren't.
So your thought would be, well, I would say that the word would be shall rather than must, but which clearly it's not. And I wasn't reading it to suggest that the exception only related to that. It said, and inasmuch as the minimum side yard setback normally on a commercial is 0, and we're talking about plantings as opposed to, and that you would have the authority. I don't see where you're barred from doing it.
I think, if you read 4764B,
Yeah. It talks about the screening.
yep, but you need a 10-foot buffer. I mean, you're pre-existing, we can't force you to plant the 10 feet of plantings.
Well,
But to allow a building where there should be plantings, a 10-foot buffer, I don't think we could get.
So it's your opinion that, that you don't have the authority. That's what, regardless
And I
of,
agree, you're protected by the zoning act,
no, I'm just,
and you clearly have the dimensions that currently exist, but to give additional, I think we could, it's just that this lot being next to the buffer, next to the residential, I'm sure, Dan, I'm curious what you think.
Well, I agree actually with Heather and Mark. I would just add that I don't even think the exception's applicable because it's at 0, so 4761 is 0.
Right.
So you wouldn't, you couldn't modify 0. I think that exception applies
Right,
to
right.
those other, where you want to reduce the amount, the distance. But you're already at 0, so.
You can't give more relief than
So
0.
you can't get any more relief than 0, so I don't even think that applies, and, at all. And as Mark says, it's quite clear, the language in regarding the buffer is mandatory language. I don't see how we can modify that. I think you've got to have that 10-foot buffer.
I'm the one who's always looking for, for that jurisdiction, for the authority to find some avenue for relief and not reading the bylaws so strictly, but I think in this case, I do think it's hard I can't find the way to get there, and I generally look to find the way to get there.
And whatever the intent of the master plan in promoting the, restaurants and whatnot, though, they're trying to, they're also cognizant of when you're abutting a residential, somebody's house, they want to make sure that you're right on the property line.
well,
I think before it was 20 feet, right? Under the old law?
it is, you're correct.
20 feet
No,
without the overlay
Without the
district.
overlay district, for the buffer. But
Let me say this, it's a good thing this stuff's not complicated at all, the Humphrey Street overlay district, I read the whole thing, and it's clear as can be, huh?
well, it's,
Consistent with the rest of our.
apparently wasn't,
Wow. My head was spinning.
just sort of getting back, the bump out itself, ironically, is probably more of a benefit than it is a detriment, because it in fact creates additional screening from Humphrey Street. It reduces the area where the patio is going to be.
I think you're right, I think those are good points, right? No, I think you're correct.
I don't know if a
The height-
refrigeration is loud, I don't know how much noise that makes as far as the butter.
Well, it's actually going to make very little noise because of the technology that's involved with these now. I truly believe, and you can prove me wrong, but it may be a non-issue, but the refrigeration unit itself, like most refrigerators today, are silent. You're not even sure they're on until you put your hand in there to find out if they're cold. But be that as it may, there are no windows. it's going to take some of the space, it's going to actually act as a buffer, because there'll be no passage going through there anymore. It's going to actually provide a benefit, and at the same time, it's going to make the restaurant be able to serve fresh food. I mean, there was a break point when he decided to do this. I wasn't involved in the acquisition, to be able to provide the service with the fresh food. But if it's your position that you don't possess that authority, I read it slightly differently. I didn't think it was exclusive to that section. I thought it was broader than that, and I thought it took into consideration a lesser use, which is a buffer, and a dimensional, which is much more specific.
The way I could see you getting there
I'm listening.
isn't through our board. I would see if you were able to negotiate with the abutter, buy a strip of their land, give them an easement back, or you have an exclusive easement, or somewhere so that you can make that 10 feet, that they still have the use, and you can satisfy them with what's going to be done in that area to make a great barrier, a buffer. Maybe that's a solution, but that's not for our board to decide.
Well, I definitely think that it's improving the design in keeping with 4710. And it was always my opinion, whatever it's worth, that the buffer is a lesser concern than the dimensional aspect for which the board has the authority to grant the exception. I never read it to imply or suggest that you are hamstrung in terms of granting any type of relief.
I mean, I think it was thoughtful and deliberate when they wrote the Humphrey overlay district, because they knew they were disrupting both commercial and residential
But in order to-
areas,
yeah.
and so that to kind of protect the residential, this was kind of the offering. They took away the 20-foot and to, give kind of a compromise.
If a restaurant's going to go in there anyway, and there has been a restaurant, the addition of this bump out solely for the purpose of accommodating some refrigeration space isn't going to change the dynamic between the respective properties. It doesn't necessarily function in any way that's going to improve.
But it's putting structure and use in that buffer zone. I mean, there's no way around that.
Oh, no, there's no question, you're correct. But the structure in the buffer zone in no way, unless it's explained to me, reduces the impact, because the structure is more of a buffer than having the plants. There's a fence.
Yeah, but if we let that happen here, then everyone,
Well, I'm not sure it's everyone.
It's a slippery slope.
It's a unique
And-
example, and I'm
and-
not asking you to go outside your comfort zone. I'm not.
I think so is there any way to incorporate the refrigeration elsewhere on the lot? I mean, those spaces, I've parked in them so many times.
So
They
it's
are
you,
tough
it's
to-
you're the one who's parking there.
What's that?
I was saying, so you're the one parking in there in the space.
Well, I was there a lot with when it was Len's. I was there all the time. And those spaces are a little bit tight. I don't know if you could incorporate the refrigeration onto the other side.
Well,
We could give relief for parking,
I suspect
to have less
that-
parking.
I suspect that there can be some type of reorienting of anything, but I think in the long run, you want the spaces for parking so that there's fewer cars on the street, and it was an area that had historically just been sitting there as an alleyway that's now being able to be utilized. It'll be taken away, which was the original concern when I appeared for Wynn's years ago, asking that we use that alley for
Yep.
eating, and at that point, it had never been tried before, and it was frowned upon, and it never occurred. It required COVID to allow us to expand our ability to see beyond what we've done in the past. The tables were there, there were people eating there. I suspect there was some noise that was created from those people being there. Some of that's would be eliminated by putting in this structure, which is solely for the purpose of allowing an interior access refrigeration unit. That all being said, and maybe that's a good line, if you felt that you had the authority to grant the requested relief, which was the thrust of my argument, But if you're telling me unequivocally that you don't believe you have that authority, you know, I'm not going to challenge the board on that.
I think that's what we're telling you, that I don't see the path there. Really like the project. I
It's a great location for.
done a nice job with the design, all of that. So, but it's just that
I'll
that's.
tell you, the
that's
planning board sure loved it. And ironically, I think the planning board thought that it was within their jurisdiction to grant the relief. They weren't sure, and then it became apparent that they wanted
If you,
CBA to,
if you modified it to remove the relief you need for this refrigeration and the buffer, do you need our relief at that point?
no. Absolutely not.
And
All
you
of,
have everything you need then from planning
everything that
board?
we need has already been obtained.
Okay.
We're here solely on the very limited buffer zone for the expanded refrigeration from the interior. That's it. It is de minimis, but at this point, it becomes problematic if you don't believe you have the authority.
Right, so, but if you were to move the refrigeration elsewhere on the property, like say on the opposite side, you have to redesign it and you lose parking, then you have to come back here for,
No.
you could do that with the planning
Yeah,
board?
Yeah. I don't think we'd have to come back because there wouldn't be a buffer at that point. And the other thing is, that's on the commercial side. It's adjoining a commercial building, and therefore, there's no, it could be zero theoretically.
I mean, it changes the, yeah, I mean, then it's not off your kitchen anymore. Is there, is there a basement in there? Is there someplace else you could put it within the
well,
structure?
It's something that just doesn't really work well, that's for sure. Because to bring up the food through these decrepit stairs is not something that would make a lot of sense. This made the most sense. It's the most economic way, which we thought would be the least obtrusive way. We thought because of its placement and the displacement of the tables, that it would be something that would be mutually agreeable. You never can anticipate the unanticipated, and that's what just occurred. But if you'll give me a moment, just a brief moment, so I can speak with my client. Thank you.
Go ahead for a second.
I think my thought was, if you're, because obviously they're not happy with it,
Right.
but if they worked out something with an exclusive use area, even if it was just around there to give them
Can I cover right now while
their
they're?
distance.
When they come back, we'll let we'll open it up to public comment, yep.
Right, yeah.
That would be the way to, I mean,
Yeah,
the
that
way I
would
would
make
look
sense.
to solve it.
Yeah, that's a good creative solution.
you don't know if the butters afford it or not, but maybe you can make it a lot,
They're
the
not
whole
here, right?
thing.
Those are
Yeah,
butters.
right here.
Oh, they are? I think she's in the back.
They were taken, but from before, I remember they were, when we did Glenn's.
So the.
So much noise on camera right now.
Yeah. Yep.
But they're right, I mean, they're right on it.
This is, they got the, let's get that frontage there, the way this lot cuts right and, oh, no, it doesn't, that's just a measurement. I thought it was. You go this way.
I was never at that place when it was its previous.
When's?
I was, when Wen's,
We had never made it to Zest Friends.
never made it
I
to
never
Zest,
made it
yeah.
there either,
Yeah.
hence
How
where-
long was it there?
it was there over a year, but it was COVID, you know.
Oh, yeah.
They had bad timing.
Yeah, Wen's was pretty good.
I liked it when, my family loved it. We were there like once a week.
Oh, really?
Yeah. I got two, well, I have one, Diane's a vegan, and my oldest, Isabella's vegan, so they loved it because there were lots of stuff in the menu they could have there too. It met everybody's dietary requirements at the house. See what I'm saying? If they ever worked out to get an easement,
Yeah.
or then they'd have it work out and have a nice buffer, even up front here, because if you have the food window,
No, they're, one of them,
you could look to do something.
one of this young lady.
Yeah, negotiate with that neighbor,
Yep.
at 292.
No, that was Steve, the building commissioner.
I mean, they are thinking this is the cheapest way to do it. I mean, if they put it over here, they've got an
That's right,
entire
and
kitchen
Peg
over
Producer
here.
is our audio
Flipping the whole
visual
kitchen.
team that's broadcasting this whole thing.
They're not, I don't think they're doing that big a renovation, hoping to open this summer.
Yeah.
I know, but it means like,
And in any case, the recording
flipping the kitchen
always
big
goes up too on our Cablecast website, so you can always watch it back, you know,
An easement on it,
popcorn.
because I think even if they had an easement,
Binge watching.
Yeah, exactly, binge watching the old recordings.
right, they could,
I think so, but what will happen is when
give
it
them an
just
easement
gets,
back, and then if the owner are there, and then just do some, you know, to buffer zone, have trees, plants.
no, they can do whatever they want over here.
And it doesn't matter, they got 10 feet still.
Yeah, they have to be 10 feet from there. Yep.
That's
Do this stuff all the time with one client of mine, who's always
Yeah, here.
looking to do it. Two clients of mine, I think it was one in Revere, if you worked on any, you know, my partner Brian's client, Mario Zupaj. You see him coming through Revere at all? So Mario is always wheeling and dealing with the neighbor for an easement and stuff
that was
like
held last night.
And we weren't notified as
Up on that,
Is, if it's not a
been-
public hearing,
and it-
sign is just a public meeting, because it's
I
just a
think it is.
design
It's up
review.
behind, Cappy's.
So there's two different,
neighborhood.
Oh, yeah,
classes
Oh, yeah.
that sort of,
It's crazy up there. the
crazy
way
up
it was-
there, yeah.
I don't know who surveyed that
was done
land,
last night before the planning
But
board,
like
yeah.
their
We've had
whole,
But
issues
the
up
planning board
there,
really
yeah.
has
There are
limited
homes that
jurisdiction
the
to what they can
street
approve
is
for
like
signs, it's really but just
on
about
their-
design
to their front
elements.
door.
I can show you the plans are right
The
here.
house got built right to the street, like
Okay.
every one of them.
Did you see the sign
Streets up there
plans?
where you know, the public way.
They hadn't
really
been
wasn't
finished
laid
at the
out-
last
really
meeting.
Wasn't
They're-
laid out
Yeah,
that
that's
clearly,
what I'm saying,
so,
yeah.
yeah, so people have their front
What
lawn
about it
is like
specifically?
in the public way.
Yeah, that's, there's some that the
So-
stairs are,
Yeah.
back front stairs.
Right, it's wacky.
It
yeah,
is.
it's really
So, we,
Yeah, 'cause I just got
when the
involved
board
with a piece of
reconvenes, we can talk
litigation up
about
there.
that.
Yeah,
Yeah.
There's a drainage issue up there.
Oh, yeah,
It's
did you
got
get involved in that
fixed.
drainage?
Yeah.
We were trying to get, we wanted the developer to put drainage up there.
Yeah, so we represent the
Yeah.
developer,
couldn't make him
Bobby
do it.
Mahoney and
Okay, yeah.
Mario.
Yeah, we couldn't make him do it because it wasn't a
Wasn't there,
subdivision.
so
Keep
but
it
we,
until they come back in,
Yeah,
and then you
yeah,
can,
yeah, and I'll,
no, you definitely get a chance to say everything you want to say.
the,
Yeah, of course.
big developer.
It just, we can't do that yet.
So they gave us, they own the land, they gave us area, that we just signed it all up this week.
Oh, really?
And the work's gonna get done, I think starting next week.
Who are you dealing with the city?
My partner Brian was dealing
Like,
with,
if they don't need,
I don't know
The
who,
engineer, Nick?
yeah, the town, the city engineer was involved, and the engineer for the developer, was the same group that did, the 40B around the corner here. And they designed the solution, so it all worked out. Yeah, it was, collaborative was good.
like, just curbside pickup, like, you know, the mobile order.
Yeah, Paul, the solicitor does most of that kind of easement stuff, and
Yeah.
buying land and strips of land. and-
I tried to look and see if like the nation has a lockout window and then like it's cream and they don't have special permits.
Right, then I had another one right across the street.
This is, if I could have, we're gonna ask if we could just continue this to the next meeting. We're gonna see what we can do about trying to reconfigure in a way that's going to make it less of an issue for you people. And
Okay.
ultimately, it may request that we just
Do you wanna ask
withdraw
them?
it, find another way that won't require any relief from this.
okay, we're gonna give a chance for public comment, for the abutters to
Oh,
speak.
sure, that's. Can we ask two more questions after the public?
Oh, sure,
Yeah.
yeah, I would think so.
All right, so who would like to go first, and just say your name and address?
So Dan Grimes, I actually live at Farragut Road, 22, but I do own 292 Humphrey Street. And always looking to see,
And 292 is the one that's right next door, that abuts this, yep.
This is the famous fence, he's on the other
Yep.
side.
yeah, exactly. And I'm all for restaurants, and I was very happy you guys bought that and want to come in, but we do have a couple concerns. So one of the concerns, and I just don't know if this board has jurisdiction on these concerns, but one concern is the driveway. So with regards to the takeout, and I don't know, we talked a little bit about this last month. So one of the concerns is that what happens is that there's a lot of parking on Humphrey Street, and sometimes the driveway on the restaurant side is
It's not-
full. So what they do is they park in my driveway, they go in to get their food, and we can't get in.
Yeah.
Several times I've had to call the cops because I'm sitting on Humphrey Street waiting to get in. I don't know how we address that or how we change that, but, oh, you have elderly parents down there that need care around the clock. So I don't know what we can do with that. And my other concern is with the takeout window is the hours of operation. When we were talking on I think it was the planning board last month, they have food service till 1 o'clock in the morning. So I know Andrew, right?
Yes.
Andrew had said that they were going to probably shut it down around 9 o'clock or something like that, but there's no, I don't think there's hours set in stone.
Can I just give you this just so we can hear you on the recording?
You don't have jurisdiction over that though, right? Isn't that all planning board?
It's all within the jurisdiction of the planning board.
Yeah.
Yeah.
So we don't have jurisdiction over that. And does our zoning bylaw address takeout windows at all in any way? We were just,
It addresses curbside pickup. Curbside pickup is listed as a use in the table of uses, but then we don't actually go to define curbside pickup in our definitions. So, can is
Right, it's
curbside
not a
pickup?
drive-through, you're not bringing a car through.
yeah, it's not a
Right.
drive-through. We have a lot of,
Well, and then drive-throughs are a separate use as well.
Right.
And then, but is curbside pickup specifically where you place an online order or a phone order, and then you go and you park in one of those designated 15-minute spots to go and grab your food
grab
and
the
then
food,
go
right.
back? Is that curbside pickup? How does that differentiate from a takeout window? Or how does that differ from a takeout window? But takeout windows
It's just a walk-up,
specifically
yeah.
are not listed as a use in
Yeah.
the table of
so it's not
uses.
addressed, so we don't, which doesn't give us jurisdiction over that. The first concern about the driveway, I don't know if we could put some signage that could be helpful.
Well, that would be the DPW has jurisdiction over the street to put signage.
Or just, but could you do signage that was just kind of personal signage that?
I would say this, we will do what is ever necessary to ensure that our patrons do not park in front. And we'll, if it happens, you let us know. We can't always curb bad behavior, but we're working with you. We don't want to have an issue with a neighbor. It's just not, it's not in our best interest either.
Right, and
Just,
as a
you know,
neighbor-
it's only good faith at this
We
point.
don't want to have an issue either. We want to be very good neighbors, because I want to go into his restaurant and eat.
And enjoy it, yeah,
He
definitely.
wants to make sure that he still lives after he goes in and takes the.
There's a work,
We're
the
sure that
driveway's
would-
right there.
It's a concern, and that's why I wanted to speak here. And,
So that's
you know,
something you could address with the DPW about signage, but also, I don't know if there's if there,
Something, call the
Unless it was
police.
just
If
on
somebody's
paper.
parking illegally in front of your house.
yeah, but he has gone through that with other, so you get his.
It doesn't work?
It doesn't work.
Okay, I don't know. I haven't.
No, so I did call them once, and they said, I'm sorry, he's chasing somebody else, we can't help him.
Yeah.
Couldn't get them to even give their,
My suggestion earlier, that was not a zoning
Parking ticket.
suggestion about
I just want to say one more thing, if I
land.
may.
It's-
And it's not
Private.
Andrew, it's not you, or the company. It's because I know he wants to work with us, which is great. I'm very happy about that. That's all I want to know about. But if it's the next person. If we set precedents here,
Exactly.
it's the next person down the road that I'm not friendly with, I can't talk to, and they abuse the situation.
exactly.
What about is all the relief done with the ABCC and the select board?
Yep, they've approved the liquor license.
Right, but isn't there jurisdiction, so if there's like an issue with liquor license, the select board through the
Oh, yeah,
ABC
they still
retains
have authority,
jurisdiction?
absolutely.
Right, so when
But
they're,
that's already been approved,
right, my point is, there's a remedy if there's violations of their
Okay,
license.
I'm sure there
or-
won't be, but again, there's that person who, not the restaurant, but the person who drives up and says, I'm gonna park right here, I'm running for 5 minutes.
Yeah,
Yeah, what do we do about that? That's my question.
yeah, no, that's a fair question.
DPW.
Deep Gino would be the guy to call
For
at
specific
DPW,
signage.
ask him about signage, and
Yeah,
they'll locate a sign there if necessary to point, I mean, it should be obvious to a driver that there's no parking in front of someone's driveway, but.
you would think so.
You would think.
No, it's someone who just doesn't care, but
You
it's.
can't control bad behavior.
It's someone
That's
who's.
Maybe signage would be good, or something that we could do.
Well, something, and then maybe the petitioner, they might be able to, put something, a little sign right there that's portable that just says, please don't park in our
Park
neighbor,
here.
in front of our, don't block our neighbor's driveway, or
Yeah, yeah,
something that's easy to put up and just keep there and just to make sure people get in the habit of not parking there, those ones with bad behavior.
Right, okay, thank you.
State
Yes,
your name and. You just
Moira
need to-
Farrell, I live on 16 Blaney Circle. I live behind the restaurant. That's lot 202 there.
Yep.
And firstly, I'd like to say I attended the planning board meeting, and my response to that meeting was that they approved the restaurant, but did not approve the bump out, and there was hesitation about the takeout window. My hesitation about the takeout window is late at night, there's a lot of late at night activity over the past 10 years that happens. Usually inebriated people. So that is one reason why I object to that window. The second reason is, as we see walking down the sidewalks at G's, right down to Popo's, and when Mission on the Bay was open, those sidewalks come July, August are all sticky. No one washes down that sidewalk or picks up the food that's left there. Since the restaurant, and I know that Ken and I attended those meetings when the Vietnamese restaurant opened, a lot of promises were made and were not kept. Most specifically, the garbage. And first time I've had rats in my yard. I wake up almost on a daily basis picking up sushi, scones, muffins. And it's just not from that building, but it's also from G's. I hear from G's, and not since the restaurant, Zest Friends has left, a constant hum. It's like you have tinnitus. Excuse me, stutter. It's like having tinnitus, and you hear it the first, like sometime around, when Zest Friends, 6 in the morning, and you hear it till midnight. Okay, this is like this guy right here. I don't know if you can hear that. And when Zest Friends is on, their air conditioner and their ovens are at a roar. And I am probably less than, 10 feet from that oven and from that, which, it just really stinks. That impact on that neighborhood and the noise that is generated from the parking lots and the HVAC system is really, I have 2 sound machines going on. I can't open my windows. The wind comes in from the southwest, which is where, in the summertime, northeast, if it came in, was opposite, I wouldn't get the smell of fish cooking, burnt grease oil. And the thought of adding with this bump out, or it's a refrigerator system with another refrigerator system. I don't buy silence and electric, and I don't buy it. I've heard many promises from all sorts of representatives, from clients, from the Concordia to the ship's watch, things that just don't happen, that people are promised here, and it doesn't happen. I'm asking the zoning board to honor the zoning laws. So many projects on that street, from Dr. Plaka's. How did that dormer, I didn't go to the meeting because it was going to be a dormer, and there's a ranch house on top of a 2-story building. How did they tear down, we fought to save Captain Jack's or put something more appropriate. And they're all promises of view quarters here, view quarters there. You'll be able to see it through the lobby. No, you can't see the ocean from there at all. The benches that were supposed to be in front of the other 3-unit building, where did they go? They were supposed to be for people waiting for the bus or for people walking by, and that was part of the settlement there. They're gone. And you know what? people in that condo park in front of those parking spaces because they don't want all the delivery trucks blocking their driveway. And those delivery trucks are extremely noisy with their refrigerator trucks. They are a nuisance. And I will conclude by saying noise pollution is becoming increasingly problematic, along with light pollution, as a health risk. And I'm here to attest to that. I strongly object to this bump out. It's just not a good fit. And they're erroneous when talking about the tables were used for Zest Friends. I only saw the tables on that alleyway just, a few months before they sold. That was in preparation for selling. Thank you.
Thank you.
Could I just say one thing?
Yeah.
If there are items that were promised, I can tell you, so I wrote the decision, I believe, on Concordia. I was named as a party in the litigation over years with Dr. Plotka, and been on this board for a long time, much like Dan. And if there are items that were promised, they made it into decisions that this board wrote. And if they're not delivered, we don't have the authority to enforce, but our building inspector does. So if the decisions are all online, they're also available, through our planning department. You can read it. If there's a promise that, it's more than a promise. It's a requirement of the relief that was granted. If it's not there and it was in the decision, there's relief because there's a violation of that decision. So, we don't have jurisdiction to do the enforcement, but we have jurisdiction to make sure it's in our decision, and that's what we've done very meticulously over.
Why is there a fireplace straddling two property lines? Whose jurisdiction does that
I'm not sure what
follow?
property you're talking about.
Plotka's.
So, with
I know they
with
needed
Dr.
to.
Plotka, there was litigation for years over various issues, and with the town and what happened with the structure. So simply because a landowner has done something with a structure doesn't mean it was relief that was granted by the ZBA. You have to go back and look at the history.
Who enforces the zoning laws?
The building inspector does for the town.
Why is that structure still?
Usually it needs to be initiated, so you bring a request for enforcement as a citizen, or you bring a request that the building inspector make a determination on your request that he enforce the zoning law. And then the building inspector makes a decision whether or not there's a violation, and then if there is, we'll issue a cease and desist letter or look for enforcement. But typically, the building inspector isn't driving around reading every decision and saying, is this person in compliance? Usually, because there's so much on his plate, it takes the citizen.
Excuse me, my point that I'm trying to make, a lot of people say things that they're gonna deliver, and it doesn't happen.
And that's why it's important for us to get it in our decision.
And that's why it's important that zoning laws are enforced.
Yep.
Buffer laws are,
Yep,
you know.
and I think
would
that's what
like
you
to-
heard from this board tonight.
Yes, and I appreciate that. And I'd like to hear about noise buffers.
Well, I remember, when you talked about the noise and you were concerned about it with Nguyen's, and I remember the representations that were made about the sound. And I don't know if I wrote that decision, but I know I was involved in that. And there are specifics that were put in there about the decibel level and the equipment that needed to be on there. So we did everything we could. If it was above that, and I feel for you because I have tinnitus, so I know what it's like to hear the noise, and there's the ability to enforce. You just need to take a look at that decision.
Now, would
And
that decision ride with the property for this as well? If this is
that's the
that
current.
decibel level?
If there's so we issue that decision, and that then we had Zest Friends come after that, so the equipment was still there, the equipment is grandfathered, but if the equipment is not in compliance with the relief that was afforded for that use, it's in violation. So if it still wasn't.
Even today, even when they open, if the decibel is louder than.
Well, I would say if there, there's new zoning relief
Well, there
that's granted by
isn't.
the planning board. I don't know if the planning board referenced the earlier decibel levels or things like that in their decision. But that's where you'd want the teeth, is in the written decision as to, if they have, there's a live question as to whether or not they codify or change the relief that was, or the conditions that were required about equipment that's on the building. So it's a question of how the decision's written and how the vote is granted.
So are you ready to continue? Is that what you'd like to do?
I'm sorry, could you repeat?
Would you like to continue to next month?
I'll let you know exactly what we're.
Well, we'll continue for tonight, and then if you don't want to go forward, you'll let us know.
Yeah, then you can withdraw.
Yeah, and you'll allow us to withdraw without.
What's the next,
I do have one more comment, if I may. So there are a lot of restaurants in Portland, Boston, Salem, that they have access to the refrigeration in the cellar. They have a flush, they have an elevator, you drop the cakes there. It may be more expensive, but it would certainly work better in the area.
Yeah, it seems like it's a doable option
You know,
that they might work on.
it's ironic, and I know I'm interrupting and I shouldn't. The irony is if a restaurant goes in there, the issues that you have just addressed to this board are not addressed. I mean, you have issues that have nothing to do with this walk-in refrigeration unit. You have a myriad of other issues. So if a restaurant goes in there, you're still going to be contending with those problems because of your proximity to a business, and that's not going to change. We're going to do whatever we can, regardless of what this board has done or the decisions. We're going to try to accommodate you. The one thing that you'll find, and this was addressed earlier, which you don't know who the successor will be. I have the word from Mr. INGEMI, I know he went and spoke with you. We're going to do whatever we can. We purchased the property. We're going to do the best we can with it. But the concerns that you have raised are not being addressed by this board because it's outside. The only question that we had for them was the allowance of a refrigeration unit on the side that is the least obtrusive and in the back. And the board feels that it cannot grant that relief, and I understand that. Whether I agree or not isn't even important. But what should be important to you is any of that, what this board has decided to do, it's not going to have any effect on you, one way or the other. Whether it goes in there or it doesn't, your concerns are restaurant concerns and business concerns and concerns of other restaurants on Humphrey Street and a myriad of other things which are beyond our control and beyond the control of this board. But we'll do what we can. I just want to leave you with that
I
thought.
think they're also the concern of the noise of a exterior, refrigerator
All
is
of the.
relevant
well,
to this.
What I was advised, and I know we're going well beyond the scope of this hearing, what I was advised is that whatever sound is going to be so de minimis, you won't be able to hear it. Now, if there were no sounds in the world, and you were in the middle of a desert, and that was the only appliance running, you might. But there's so much other ambient noise on that street that you'll not be able to hear this. You won't be able to hear it. But my representation will have no direct impact because that's not the issue. The issue is the buffer. And this board's belief is that you don't have the authority to grant it, and that's what we'll.
what's the next date?
Unless I can come up with something.
So, yeah, the next date
now,
is June.
America,
Put a wrap on this.
To find out that we do have the
Beating a
authority.
dead horse.
I know.
June 13th.
Oh, it's
13th.
dead.
Okay, so I'm going to make a motion to continue this to our June 13th.
You need me to sign a
Hearing.
letter to extend?
Yes.
Sure, I'll email you one
What's the
tomorrow.
next date?
June 13th.
June 13th?
Second? Yeah. All in favor?
All right.
All right. We will see you then or not, depending on.
You'll see me then on the other matter, or not, because they keep on not getting what they're supposed to get in,
Should I-
so.
I'll text you.
Yeah.
I'll
He would have done
have
he would have done a wonderful job.
I'm sure he would, and the plans are clear
Yeah,
and
text me,
everything.
but
We
I'll
did have
be,
everything.
it'd be nice to see you too.
And, you know,
give us wonderful
sometime I want to
presentation.
replace that.
When do you guys plan to be open?
It's a pipe dream at
Thanks,
this
Steve.
point.
Yeah.
It's
See you
gonna-
tomorrow.
It won't be in the near future,
Yeah.
but
Yeah,
I'm sorry.
it is rotting. and
that's okay. Maybe we don't see that.
Yeah.
I'm trying to do a little bit more upkeep in the yard too.
Yeah.
Thank you.
Okay, take care.
Oh, yeah, we go do that.
Move to adjourn.
Yeah, and I'm sorry about that little
Second.
no
All right.
man's
favor of
land
adjourning?
there.
No,
because-
I only
Bye.
said because one of our old neighbors used to put plants there.
Yes.
And it was really nice, but I,
It's a tight
do I
spot,
want to get rid of, I don't know.
Yeah.
The one between us and Burlington, you can't, there's no physical way I can get in there.
So if I see something in
Every once in a while,
there,
there's something about it I cannot determine
I'm
what
gonna
it's
have,
really
I'm
trying
gonna
to say. This is
call
one where you
Flannery's. and
really,
just gonna
there's
come in.
nothing you can do.
I'm the one that's always trying to find
Because those
I know.
Okay, thank
Thanks.
you.
It's good to see you.
Right, Dan, I want to agree with you on for the strict interpretation, there's no wiggle room I could have in there.
know, there was no wiggle room.
Yeah. Good, yeah.
I was there, that's Santorini.
So June